SJC-13207, Commonwealth v. Pingxia Fan.
Okay, Attorney Osborne, when you're ready.
Yes, Your Honor. Good morning, Your Honors. My name is David Osborne, and I represent the defendant in this case, Pingxia Fan. And I appreciate the chance to raise this issue. It's an important issue. There's several issues that we raised in our brief, but I'm going to talk about the issue primarily that brought us to the dance here today, which is the question of whether a jury has to unanimously decide on the particular person who was trafficked under the sex trafficking statute for Massachusetts. And there's a reason why I think no court in Massachusetts has ever considered this issue. The reason is that I don't think I've ever seen a sex trafficking case that is not victim-centric. In other words, each count is linked to a specific victim, conduct against the victim, and that's how the Commonwealth proves the case. And that's logical because these are trafficking is a crime against a person. So it would make sense that you would show how the prohibited conduct affected a particular person. And that's another reason, by the way, Your Honors, why some of these amicus briefs that talk about the sky falling, if Your Honors agree with our interpretation of the statute, simply aren't correct. The Commonwealth routinely alleges and proves a specific victim for human trafficking crimes. I am not aware of a case, and the Commonwealth has not directed us to one, that is different, except this case. This case is different. This case is not victim-centric, it's venue-centric. And in this case, each count is based on where the conduct took place, not the person against whom the conduct was directed. The trial court, I think, said it well.
Counsel, can I interrupt you? Because I just want to focus on just the fundamental statutory construction issue.
Sure.
And to the extent that we have our construction law that tells us that we don't put stuff in or we don't read stuff out, why can't we just say in this case, I understand that you've seen it as applied in other types of trafficking cases, but if we're just focused on the words of the statute, why doesn't a person just mean what it means? A human being, another individual. Why do we have to go any further than that, particularly in this case where there was a lot of evidence that there was another individual that was being used in this way in the trafficking sense?
Sure. Your Honor, that is the heart of the dispute here, and you have articulated the Commonwealth's point of view, which is that the statute says another person as long as there's some other person.
Why is that wrong?
It is wrong, and the reason is because you need to have a unanimous jury verdict on the specific offense that has been criminalized by the legislature, and that brings us to Pompolis, which is a case that we cite. And I know the Commonwealth says, well, it doesn't really have anything to do with it, but it actually has everything to do with how we arrive at this position. Because Pompolis is a case about what is the unit of prosecution for a sex trafficking case. And in that case, and it's unpublished, I understand that, but I think the logic is sound, and this court should agree with it. It says that the unit of prosecution is it says the purpose in arriving at the unit of prosecution. The court says that the purpose of the trafficking statute is to punish conduct directed at a discrete person, or in another place it says a specific person. But the idea here is, or a specific victim. The idea here is that it's not just conduct that you engage in that violates our societal norms. That would be, for instance, driving support or other kinds of public order-based statutes. This statute, as a crime against a person, requires a discrete victim. And to your question, why isn't it enough to say it's another person? Well, the reason is because you have to prove a separate criminal act for each count, right? You can't just lump all these actions together and say, pick one jury. You don't have to agree on it unanimously. If the specific separate criminal act in each case is the discrete victim, as Pompolis tells us, then you have to the jury has to arrive at a unanimous decision about who that person is. And usually it's not even an issue because the Commonwealth, its proof is that there's only one person who could possibly be the victim for any particular count. But when you have...
Let me push back on that for a little bit, because here's the other side of that. When you started your argument, you said that this was focused on locus, right? And so when you think about these different counties, where you have Suffolk County, Norfolk County, Middlesex County, it wasn't as if there wasn't evidence. And if you look at the way that it went through seriatim in trial, for every county, they had one or more people who purchased the services testify to going to the place, purchasing, paying someone in cash for what ended up happening, that there was someone there that accepted that money and performed the sexual services. So to the extent that you're concerned about perhaps somebody being convicted here where there isn't any more defined who that was, there was testimony from the actual John, right? That I went to this place, I paid this money, somebody met me, somebody let me in, somebody did the services, and I left at this location. So again, if we then infuse this word into the statute, which is seemingly what you're asking us to do, all of those prosecutions go away. And if to the extent that we're talking about criminalizing that conduct of deriving income from treating people this way, wouldn't that defeat the legislative intent of this statute?
That's not the statute, Your Honor. That's a different statute, deriving income from commercial sex.
Yeah, understood, but there's also, if you look at the terms of this statute, right?
Yes, and I understand you're raising the evidentiary question of wasn't there enough evidence here that there was another person. Well, here's the problem. The problem is that we don't have anything that links the defendant's conduct to any of those actions. You have evidence, of course, of customers who have been provided with sex by people who are at these places, at these venues, or apartments, whatever you want to call them. But there's no evidence whatsoever as to the defendant's conduct against those particular people. If there was some evidence, perhaps the identity of the person, the specific person, wouldn't be important. But there is no evidence.
Well, there's no direct evidence, but there's circumstantial evidence, right? I mean, Ms. Zhao testified, right, that your client was Lucy, who told her that this is what you're expected to do and brought her to these three different, so there was evidence of it.
Well, there was some evidence, but first, two things. First, you don't know what the jury unanimously agreed on. And I'm going to refer to as BX because that information is actually impounded, so I'll refer to them by initials, but I understand the person you're talking about, Your Honor. Mm-hmm. BX testified that she did give some testimony about my client's involvement in trafficking, but there's a couple of things. First of all, we have no idea if the jury credited that because she was originally charged as a co-conspirator. She was not charged as a victim. Her status as a victim transformed when she entered into a cooperation agreement against the defendants. And that was brought out at trial. She was cross-examined extensively on that. There's no particular reason to believe that the jury gave credit to her evidence, and she's the only victim who testified. The other important question on BX is, as I said, you have to prove each count, right? You can't just say, well, there are women wearing bathrobes, there's guys who are having sex with women in these places, so that proves it. There's another person. You have to actually link the person you're saying is the victim to the particular count. And that's where the Commonwealth's case fell apart, because what the Commonwealth failed to do, and I think it's because the Commonwealth never even thought it had to do it, but the Commonwealth never made any attempt to actually link a specific victim to the conduct that was happening at an apartment, except in one case. I will grant you this, Your Honor. Count 7, I do think that the evidence potentially was sufficient for count 7. That was at the North Central Avenue apartment in Quincy. I think her testimony, it's thin, but I think her testimony would be enough, except that we don't know if the jury unanimously agreed on that. That's the problem. But with regard to every other count.
Can I ask exactly what you're, I'm reading your brief. Defendant alleges that the phrase "another person," well, that's a Commonwealth brief. Another person requires the Commonwealth to identify a named victim. I'm just trying to make sure I understand what you're asking.
Yeah, Your Honor, there's a lot of misunderstanding about what our claim is, even though I thought it was pretty carefully stated in our statement of issues. What we say is that you have to identify, the jury has to unanimously agree on the particular person who was trafficked.
Well,
you don't have to agree on the name. There are cases that are cited in some of these amicus briefs, but they're all about the sufficiency of the indictment. It's got nothing to do with what we're saying. We're saying there has to be unanimous agreement on who that person is.
Was the
Now,
jury instruction wrong?
pardon?
Was the jury instruction wrong in that regard?
Well, it was wrong in two ways, Your Honor, and there's two pieces to that. That's a good question. One is that it failed to give, the court failed to give the instruction that was requested, which was on specific unanimity on this point. And the second is that the judge actually, for some reason, I don't quite know why, it wasn't requested by the Commonwealth, but she went a little further and she said you don't have to agree on the specific identity of the person.
You have to prove that a person's engaged in prostitution.
Just exactly. Somebody's
As long as
engaged.
again, tied to the commercial
Yeah, and that's the problem, Your Honor.
locations.
I just want to emphasize this. It's the one point I want you to take away today is that there has to be we know what the specific act is. It's trafficking against a discrete person. You cannot.
Well, the statute doesn't say a discrete person. It
Well,
says
that's
a
what
person.
Pompolis says is the criminal act.
Well, I mean,
Obviously, the statute doesn't include a name of a victim. You can't. That's case specific. But I think the only way you can interpret this and to ensure that you have a unanimous verdict on the specific wrongful conduct is if the jury agrees on who it was directed at. There are many cases, we didn't go into other states.
But are you relying on the cases where we've got these child rape cases where we've got a bunch of incidents with the fathers abusing the child and you ask for a specific unanimity instruction so that we pin down the date or I'm confused.
It's akin to that. Obviously, this is a very different statute. But yeah, the bottom line,
Is that because there we're dealing with a danger that some of these acts may not be proven convincingly to all of them. There's enough here. There's not really ambiguity. We've got, as Justice George says, the particular John on the particular date is.
the Johns, Your Honor, they don't tell us anything because there's no evidence that says Mr. Hayes or Ms. Phan was engaged in trafficking these women. All we know is that sex took place there. That's all we know. So that's the problem. You have to link, there has to be a link between the defendant's conduct and a discrete victim.
Well, you
That's
just
the other person.
melded two very different things. Okay, you just said that John can't tell you that your client was the person that put all of this in play. That's a separate question. That John can tell you they met with someone.
Right.
That they met with a person, which is and engaged in commercial sexual activity. Tying that back to your client, there's other evidence of that. That's not what we're talking about.
But Your Honor, you're disconnecting the prohibited act, the trafficking, the harboring, the enticing, whatever, from the victim. By saying, well, there's proof that there's sex going on, right? And there's proof that the defendants were engaged in harboring, trafficking, enticing, recruiting, whatever. And that's enough. But you haven't linked the two. You've got to link the two facts. You've got to link, because that's what the statute says. If you want to go to what the statute actually says, it says another person, and it's in the singular. It's not in the plural, which means it's an individual person. It's not the world at large. The legislature did not say any person. It said another person, which means under Wasserly, this court's a case that this court recently considered. That means it's an individual human being. And that's what the instruction
Well,
was.
it means that it's an individual human other than the defendant.
I think that would be reasonable, yes, Your Honor, because there is potentially an issue here about whether Ms. Fan, who admitted to prostitution, or her counsel admitted to prostitution, that she engaged in prostitution, potentially the jury could have convicted her on that. But that's an absurd result. We're not suggesting, I don't think anyone would suggest that the trafficking statute prohibits somebody from trafficking, or you can be liable under the trafficking statute for prostituting yourself.
Are you suggesting there's a danger, because trafficking, we're trying to protect the victims of the trafficking,
Yes.
right? That's one of the reasons.
Absolutely.
There's some protection over their identity. Are you suggesting there's some danger here that by not, I mean, you could have asked, I want a unanimity instruction on whether there was trafficking on this particular event, right? If you're basing the trafficking conviction on these 3 different events, I take it you could have asked for that, or is that what you're asking for?
No, it's different, Your Honor, because the statute, I don't know that would, because I don't think you necessarily need a unanimity instruction on the means. What you need is on the act, right? What constitutes the offense? Pompolis says the offense.
I mean, is that because there's a danger that on this day it was just a massage, and on this other day it was
Or it's
a sexual massage?
It's a little different, Your Honor, but something like that. So you could imagine a situation where, in this case, on, let's say, count 7, which was the Quincy, one of the Quincy venues. You could imagine 6 jurors sitting there and say, well, yeah, I think that Ms. Fan trafficked person X, at that place during that time frame. And you could imagine 6 jurors saying, well, I think that she trafficked Y during that time frame at that place. Now, under the instructions that the jury received, all they had to do was decide that there was trafficking at that place during that time, and somebody, disconnected from any of those events, somebody was there engaging in sex.
I'm confused. So if the jury, if all 12 jurors agreed that there was trafficking with this person on that event,
Right.
the danger we're dealing with is what? That
Because-
that her name was X rather than Y?
No, it's not that, Your Honor. It's that the statute, again, I go back to Pompolis. Pompolis says that the prohibited act, is conduct against a discrete person. You can't just ignore that piece of it. That's what distinguishes it from, for instance, it's not like it's distinguished by venue. It's not like, well, if you could engage in trafficking at this place, then that's a crime. That's obviously not what the statute says, because it says if you engage in trafficking against another person. So Pompolis says it's got to be directed at a specific person, a discrete person, and I'm not suggesting that in every case you need to go through this instruction, but when you have multiple potential victims, some we don't even know if they are victims, they may not be there because of any conduct that the defendant's engaged in, or they may not be victims that the jury would find credible, for instance, BX. You have to ensure that since the offense is the conduct against a victim, you have to instruct the jury if requested, and if there's a possibility of some confusion or a non-unanimous verdict, you have to instruct the jury. Agree on who the particular person was. It doesn't mean that there couldn't be other acts that would also violate the count or prove the count, but you have to have one, and that's all the defendants are asked for in this case. Connect one particular person, agree on that person. You don't have to identify the name. You don't have to, do all these things that some of these amicus briefs suggested would cause the sky to fall and we couldn't protect victims. We can adequately protect victims. You could have prosecuted this case in a way that would have ensured the defendant's rights to a unanimous verdict and protected the victims. But instead, we got this sort of very novel way of framing the case, organizing the counts, so we have no idea if the jury actually agreed, yes, there was a particular person was trafficked at that place during that time frame. We have no idea, which also creates double jeopardy concerns. How do we prevent Ms. Fan from being prosecuted again for conduct against a victim, a specific victim, if we don't know who the victim was in the first place? It creates all kinds of serious problems which can be resolved very simply. If the Commonwealth has evidence of a victim, it doesn't have to present the testimony of the victim, it doesn't have to give the name of the victim. But if it can show that somebody was harmed, then the jury can agree on that unanimously.
Thank you very much,
Thank you.
counsel. Let's move to Attorney Reardon.
Good morning, Your Honor. Suzanne Reardon, Assistant Attorney General, on behalf of the Commonwealth. With me today are Nancy Rothstein and Gretchen Brodigan, who are the trial prosecutors in this case.
Would you address the double jeopardy issue that Attorney Osborne just raised?
Sure. So, first of all, and this is not my brief, I should have put it in my brief, in these cases, the various troopers who executed the search warrant at each location actually identified the victims that were found there with a picture as well as their date of birth and their name. So to the extent that defendant is arguing that, we didn't know who these people were, yes, we didn't have some of them testify at trial, but we knew who they were. We had photos of them, we had their names, and in that...
But this is about the jury finding that, right? Not just the investigators.
Right, so the jury was told, they were shown these photos, which were admitted into evidence, and, because these victims were, their identities were on the record, there isn't really a danger of double jeopardy, especially when you look at, and the important thing to remember here, as some of your honors have mentioned, is what is the underlying purpose of this trafficking statute? And I think it's very clear from the legislative history that it is to protect the victims of trafficking and to focus on the activity that these people are doing in trafficking other humans.
How does this square with our case law on child rape victims? Justice Kafka brought that up, where the danger is, multiple kids in a family, and 6 jurors believe, offenses against Adam, and 6 jurors believe offenses against Billy, and we don't have unanimous decisions that way. And we tell the jurors, you have to be unanimous as to who and in what act.
I mean, those are cases where specific victims testified. We don't necessarily have that here. We just have testimony. Well, we have 2 victims who testified. But we have testimony from each location about people who went there and engaged in commercial sexual activity, which covers what the statute says, that another person engaged in commercial sexual activity during the time frame that was named in the indictments.
But back to the double jeopardy point. So we know that his client has been convicted for trafficking on that day, but we don't know which one he's convicted for. She's convicted for, right? Because there are 6 different women working in this place. How do we know? How do we enforce the double jeopardy that the chief was just asking about? What's to prevent you from saying, well, okay, you were just convicted for the January 6th trafficking, but that was really X, not Y we were talking about. How do we solve that problem? And it's related to the other one that Justice Gaziano was just following up on.
Well, we solve that because the statute doesn't require a specific victim. We're not required, the Commonwealth is not required to show a specific named victim. Now, defendant says,
But double jeopardy is a constitutional problem.
correct, but that's only if you are tried again for, the same crime.
Right, yeah, exactly, and that's the point, is if we don't know, the jury came to one mind as to the particular victim, then couldn't the government retry on, ostensibly the same victims?
But that's what I'm saying, Your Honor. The Commonwealth was not required to show a specific victim. In fact, defendant says he's not saying that we had to name a victim, because that's what the amicus briefs are so concerned about. With the sort of the nature of victims in these kind of cases, there are many reasons why they wouldn't want to come to court and testify.
I get why you want to protect their exact identity, meaning we don't want Jane Smith, age, born on January 24th, 1980. But don't we need a database that indicates who the individual was to, well, I mean, you're shaking your head, but
Don't.
what's to prevent you? Well, I know it's nice for you because you could keep, so tomorrow, can those two ladies next to you bring prosecutions now for the exact same date? And just say, well, we had another person there. And then he's going to, well, wasn't I just convicted for that one?
No, Your Honor, that's not how our office does things,
Well,
first of all. And
I
secondly,
know you're more professional than that, but what's to prevent you from doing it as a matter of law?
well, here's the thing. The defendant just said he didn't think that it was required, and he's not asking that there's a requirement of a specific named person. So how else is the Commonwealth supposed to identify the person? I mean, besides saying what their name is, there's really not a way to identify a specific victim in the terms of saying there's a discrete, what are they going to say, an Asian woman at this location?
No, but we have, normally in crimes, juveniles, we protect their identities, but we identify them. We know who they are so that we don't have a double jeopardy problem. So there are no specifics in this thing? It's just, I'm sympathetic to protecting the identity. I understand that that's what trafficking, we don't want to reveal and cause more harm to the victims. But we do need to keep track of who the actual victims are, don't we? No?
I'm sorry, I guess we disagree on that, Your Honor. I think
Isn't the reason because it's not this case that you're worried about double jeopardy. It's some imaginary next case. And the double jeopardy claim is in the imaginary next case, not this one. You worry about whether there's double jeopardy in this case.
that's the worry, Your Honor?
No.
Okay, the next
What I'm
case.
saying is, there's no concern about double jeopardy in this case, right?
I don't think so, no.
But the concern that's being raised is a legitimate concern about another case. But that's that other case where the double jeopardy claim is going to have to be brought. You don't have a double jeopardy problem here.
Okay.
I think he's trying to help you. I think he's saying that.
And then when the next case comes, they would raise double jeopardy and you would argue against it.
Absolutely. Yes. I mean, as I said, the victims in this case, particular case, were identified by photo and name. So I don't know that we have even the double jeopardy issue.
Well, there may be. And again, although I went into the record, I didn't go as deeply as when we have to write it, but let's just give you a hypothetical. You have all of the Johns that testify, but let's just say that on the day that when one of the testifying Johns, there were two women in that apartment. At trial, did that particular John say who the particular person, maybe not by name, but identified them somehow? That's the person that I went and paid and engaged in the activity with.
They did identify by the way the person looked. They didn't, I don't think any of them testified.
But then you could see what the problem would be. Because if we were to vacate that and say, okay, now you've got to retry it, how are we going to be? You said yourself, we know that I think all of the women were of Asian cultural descent. How are we going to make sure that on the retrial, it's not the same person that you're prosecuting the defendant for? If there's no way to distinguish which one of the two that were in the apartment happened to be the one that particular John testified to having gone and engaged with.
I mean, if you're saying retry because you're going to reverse and we have to retry, I mean, I think my argument stands that all we have to show is that another person engaged in commercial sexual activity, not a specific person. So I don't think it matters.
It doesn't matter to double jeopardy?
Well, again, that's, if you reverse and we have to retry, that's not going to be double jeopardy.
Right.
I mean, obviously the defendant didn't bring a sufficiency claim here, and that's pretty telling if he thinks that there's not enough evidence to show, you know, a discrete victim, as he says is required. But the Commonwealth, under the wording of the statute, is entitled to decide how it's going to prosecute its case. In this case, there were 5 different locations, very discrete locations, where there was testimony by men who went into each location and engaged in commercial sex. There was testimony, abundant evidence, that the defendant was tied to each of these locations. She, in fact, signed the leases on 2 of them. She was observed at all of them. So there was evidence to tie her to all of these locations where it was clear commercial sex was taking place. And I argue, I know there's maybe some disagreement, but I argue that that's all that we were required to show to prove this human trafficking.
On the separate issue about the grand jury testimony from 2 women who said they were just masseuses, the separate issue about the grand jury testimony about the 2 women who said they were just masseuses.
Yeah.
Are they 2 of the women potentially that were relied on to prove this case, or is it clear that those incidents, say we were unhappy with that issue, is it clear that the case we're dealing with doesn't involve those 2 women? Meaning that, again, I don't know who the people are because you say you don't have to identify them. But are those 2 women who say they just gave massages, are they any of the same Johns we're relying on? Do we know that?
I don't think we can know that because we don't know
Isn't that a
specifically who the-
potential problem? If 2 women, we have grand jury testimony from 2 women who said they just gave massages, but those are the same 2 women that may be the source of some of these convictions, and that wasn't allowed in. I understand, we know that they weren't the 2 women, it's easy, right? But if then the judge's decision not to allow that grand jury testimony makes complete sense. But can we rule out that they're the basis of some of these charges? Because we don't know who anyone is.
Again, I'll just go back to my argument that we have shown that another person was engaging in commercial sex, and there was, you know, maybe there were 2 at grand jury who testified that they did not. There were another 6 who did. And again, I go back to the evidence from the different men who went to these locations. It clearly was, you know, commercial sex was occurring there. So that's how it, again, as you have said, the judge made the right decision in not allowing that grand jury testimony in, because it clearly wasn't, the grand jury was just somewhere where the Commonwealth put these witnesses in. It was literally the day after the search warrants took place. And they were just putting these victims in to preserve their testimony at the grand jury.